I love answering questions about trial advocacy, trial skills, and I've never answered this question before. We'll call him Jim for privacy purposes. New trial lawyer. How did I get my first $1 million verdict in front of a jury? And it's a great question. I mean, it was a case back in 1994, 95, something like that, a long time ago, that involved either a fabricated coroner or police report, autopsy report as to cause of death, or there was a mistake in the reports that led the clients to my office. It was a mom and dad to my office to investigate and possibly litigate a wrongful death jet ski accident involving their 16-year-old son. So from the very beginning, the case was unique. It was interesting. It involved something that happened at Lake Havasu in another state. We're here in Southern California. But it also involved my life experiences. I grew up riding stand-up and sit-down jet skis and watercraft. I grew up racing motocross and flying hang gliders. These sports allowed me to bring into the case a different perspective as to what may have happened and how I would be trying the case. So, Jim, great question. My first $1 million jury verdict, it happened in federal court. It happened back in 1993, 94, 95, something like that, probably about 8 or 9 years after I first started practicing. It happened after I had handled, I'm guessing, a couple hundred cases, tried a dozen cases until I finally got to that point. So it took time to get to that point, really that point where the clients knew who I was and were referred to me and came into the office. But it also goes back to how I was brought up, because some of the things that I did growing up in Tucson, Arizona, whether it's traditional sports, racing motocross, flying hang gliders, riding jet skis, stand up and sit down, all of these things played a part in this particular trial. And I think to answer your question, we need to go back in time to growing up on a ranch and doing all of these different sports during my, going all the way back to my elementary days, junior high school, and college years. And one of the things my mom and dad always drilled into me was to do your own thing. Don't worry about what everyone else is thinking. Don't worry about how everyone else is doing something. There's a good chance they may be doing it wrong. And even back then, they saw things changing in the world quickly. Back then, everything from a black and white to color TV to new newspapers, new information coming out that were available, to different technologies that were happening back in the day. And that's all relevant to this particular trial and $1 million plus jury verdict, because all these things played into how I tried the case. And Jim, when I graduated from high school, I spent more time during those years enjoying sports, doing these other activities that I've already mentioned, typical teenage activities. I enjoyed all of that more than I did going to school. It was a different world back then. And I knew that I could not put my best foot forward in high school when it came to academics and still get into either the University of Arizona or Arizona State University. And I went to U of A, which is where I grew up in Tucson. And I wasn't motivated to go to college. I had other things I wanted to do, but I do remember my dad sticking his head in my room on a summer morning, probably about 10 or 11 in the morning, and he said, "You got two options, pal. Get up out of bed and go down to the U of A and register for school this upcoming semester, or get a job, full-time job." I was doing landscaping, I was waiting tables, doing some part-time stuff, but he didn't want me, obviously, sitting around during the summer. And so he gave me a little kick in the butt, and I went down and registered for the U of A. And I registered and actually spent my first year and a half in the civil engineering school. I thought I wanted to be a civil engineer. My grandfather and my uncle were both engineers, and I thought that's what I wanted to do. I realized after getting into the civil engineering school that it wasn't my passion. And the advanced mathematics, the advanced sciences, mechanical engineering aspects, statics, these courses I was able to get through, but it just wasn't as easy as I wanted it to be. It just wasn't something I was interested in. And so after a year and a half, I switched over to the business school and took a business law class. And when I took that business law class, everything clicked. It was what I was interested in. I just love the law. I love having some foundational rules. But then when the facts change, when society changes, when things are different, as a lawyer, you can modify that change and change the law so that it's better for everybody involved. So for me, it just kind of clicked. Also over in the business school, just between us, you know, I was single back then, and there were more girls in the business school that I was interested in. And I ended up being a roommate with a couple of SAEs who were looking for a roommate. They were asked to leave campus back at the time for a little activity that went sideways. These are guys I was waiting tables with, so I moved in with a couple of SAEs for the next couple of years, and we had a good time together. But for me, business and law all kind of clicked. And the reason I'm telling you this is because when this case came into the office, right off the bat, from a business standpoint, what concerned the parents was that the autopsy report and official police report with respect to the death of their son. And let me take a step back. This was a case that took place in Lake Havasu on the Colorado River, where their son, a 16-year-old who happened to be an expert jet ski rider, was struck head-on by another watercraft operator who was an adult and ended up causing the immediate death, the instant death of the 16-year-old son of my clients. And the son of my clients didn't drink, he didn't do drugs. They had a house out at the river. They'd go out there all the time as a family. And in the autopsy report that they brought in, it talked about alcohol and drugs being in the system, which I believe related somehow to the operation of the jet ski and the ultimate death. Well, they knew their son didn't participate in any of those things. And while I didn't know the family, it was my job to find out if this report had been fabricated or if it was a mistake. And so we went ahead and took the case, and we filed a lawsuit for wrongful death in the state court. And here in California, all I need to do is get 9 out of 12 jurors to find in favor of my client for what they're being asked to determine. It's either a general verdict, yes or no, was the other side at fault, and what are the damages, or in a special verdict on each question. I just need 9 out of 12 people to find in favor of my client, and it doesn't even need to be the same 9 for each question that's asked. But what happened was the defendant driver of the other watercraft lived in Arizona. And so the insurance company brought in one of their top litigation defense attorneys, who also had his office in Arizona. Super nice guy. We got along fine. We just didn't see the facts of the case through the same lens. And they removed or transferred the state case to federal court. The reason they did that was based upon a diversity of jurisdiction. We're in California, the other side's in Arizona, so they get to remove the case to federal court. From a practical standpoint, why they did that is in federal court, I needed to obtain a unanimous 8-0, 8 out of 8 jury verdict in this particular case. No longer did I only need 9 out of 12 people. I needed to get all 8 jurors to find in favor of my client. So it's a much more difficult case to win. And in this particular case, Jim, what happened was the family had had breakfast at the lake. They were riding up the river, the brothers, the dad on their jet skis, and they turned into a narrow reed-lined passageway that they have ridden in plenty of times before. When you turn into the reed-lined passageway, you're on your jet ski, stand up, and you're basically going about idle speed. And on a stand-up jet ski, you can balance at a very slow rate of speed as you're going through the waterway. And while they're working their way through these broad corners in the waterway, what they saw and what the witnesses saw was another jet ski operator coming from the other direction at a high rate of speed behind the weeds with water splashing up. Witnesses estimated his speed at about 15 to 20 miles per hour. When he came around the corner of the reed-lined channel, he ran right into the front of our client, who was operating safely and just above idle speed. And the handlebars hit our client in the neck and killed him instantly. Almost immediately thereafter, the brother and the dad who were following our client's deceased son jumped off their watercraft and did all they could to try to save their son's life, their son and brother's life, but were unsuccessful. The witnesses testified that the other watercraft operator actually, instead of helping, instead of asking if there was something he could do, spent all of his time looking for his expensive sunglasses in the water. This is what the witnesses testified to. So those are the underlying facts of the case. So as we started getting into the case, what we found is this original autopsy or police report. I'm not sure which one it was, but the report that said that our client's son had alcohol and drugs in his system, what we found out through formal discovery, and that's where you serve inspection demands, you ask questions under oath that are in writing. What we found is the report that was given to mom and dad, my clients, was the wrong report. It concerned somebody else. It had nothing to do with our client's son or this case. Now, was that done intentionally to try to mislead them, to try to make them go away? Or was that done by mistake? I don't know how busy the Lake Havasu area is when it comes to processing reports, but in this case, what we're able to show is that this was the wrong report that the family was given, and when we obtained the correct report, there wasn't anything in the bloodstream of the young man who was killed, our client's son and brother, with respect to alcohol or drugs, okay? Nothing at all. And so we pushed the case forward and we tried to settle the case. In this case, there was a boat policy, liability policy that was covering the other watercraft operator. Now, the other watercraft operator was someone who was well respected in the community. He had a Navy background. He was over 50 years old. Obviously, he didn't mean for this to happen, but he wasn't accepting responsibility for what happened. And he was covered by a $300,000 boat liability policy. So what we did is we talked to the parents about what are our settlement options, what are our trial options, how much does it cost to take a case like this to trial. And with my business background from the U of A, with my engineering background, looking at speed, distance, and location of where this happened, all of these things, you see, Jim, all of these things play into what we're looking at as trial lawyers. You know, that 10,000 hour rule, you got to do something for 10,000 hours before you get really good at it. I'm a firm believer those 10,000 hours start clicking really the day you're born, the day you can start to remember what you've done. And in this case, because I knew jet skis and I was comfortable with these types of activities, how jet skis operate. And for those of you that don't ride jet skis, in order to be able to steer a jet ski, you have to be on the throttle. And if you're not pushing the throttle while you're on a jet ski, it's not going to turn. It's blowing jet water out the back. So you have to be on the throttle to be able to turn the jet ski. The more you're on the throttle, the faster you're going, the quicker it reacts. And all of these things came into play, and I'll get to it in this particular case. But we ended up making a policy limit $300,000 settlement demand. Now, you're not going to believe this. In response, the offer that we received from the other side's insurance company was $1. Was $1 to settle the case. And, it was insulting. It didn't take the facts and evidence into consideration. It certainly didn't take my client's best interest into consideration. And it was made for a strategic procedural reason. And the way it works is if we didn't do better than a $1 verdict in the case, in other words, if the jury came back and said, you know what, we don't think the defendant caused this wrongful death, then my clients would be obligated to repay the other side for their litigation-related cost, expenses, and expert witness fees, along with some other expenses. So if we lost the case, our clients would be looking at having to pay the other side a lot of money if the other side made that demand. But we believe that's why they were making the $1 settlement offer. So we continued to push the case to trial. When the case was removed to federal court, so remember, I don't just need 9 out of 12 jurors now, I need 8 out of 8, which makes it pretty tough. Here's the reality of the situation. The courthouse that we were trying this case in, the federal courthouse, was in downtown Santa Ana. It was closer to my office, closer to where my clients lived, and further away from the Arizona-California border. The defendant and the defense attorneys and the claims adjusters had to travel from Arizona all the way to California, all the way to Santa Ana, California to try this case. We originally filed this case out in Barstow, which is on the border of Arizona and California, and the closest courthouse to Lake Havasu and where this happened. It was the most convenient venue to litigate this case, but they made us, they removed the case to federal court, and we ended up trying the case in Santa Ana, which was fine. So we took the case to trial and found out during their opening statement and looking at the diagrams and through the discovery process that they had recreated the entire collision using a helicopter and using accident reconstructionists and put together their version of what they believed happened. Now, we had found 2 eyewitnesses to the collision whose testimony agreed 100% with our version of the case, of what the dad saw happen to his son, of what the brother and cousin saw happen to the decedent. But the other side just disregarded that information and went with their paid experts. And the way it works oftentimes is you pay an expert enough money and they'll take the witness stand and say what you want them to say. Now, I don't know if that's what happened in this case, but I will tell you that after listening to their expert testify as to what happened and use the video and the diagrams that God knows how much money they spent putting all this together, they had one problem. Their problem was their whole accident reconstruction involved a corner of this reed line channel that was right here. The collision happened over here at a completely different corner. They didn't realize this until after the expert testified in front of a jury. So on cross-examination, in addition to some other things, I was able to cross-examine their expert and get him to admit to the jury that other witnesses placed the scene of the collision at a corner or location at a completely different place. We're talking 100 meters down the reed line channel at a completely different place than where the accident reconstruction video, chopper, diagrams said this collision took place. And by the way, we were right. There are other issues involved here, but the point being is once I was able to cross-examine their expert, the jury knew that they were either being misled or the other side was mistaken as to where the collision took place. And if they were mistaken as to something as basic as where the collision took place, then guess what? Maybe they were mistaken about some other things in the case. As we started talking to witnesses in front of the jury, witnesses who were on the witness stand, we talked about watercraft operation. We talked about how the throttles work when it comes to watercraft. They don't have brakes. Okay, so if your watercraft doesn't have a brake and you want to stop it, what you need to do is you need to back off the throttle and you need to plan ahead of time as to how much longer are you going to continue to move forward. Should you turn the handle of the watercraft and hit the gas and bank tightly to the side? There are a lot of different ways to either change direction or slow down your watercraft. And it's because of the years of experience of riding watercraft and doing water sports, even water skiing is kind of similar as far as using the pressure of the water while you're turning. All of these things allowed me to effectively cross-examine their witnesses, come across in front of the jury as someone that had a good working knowledge of the facts. And when it was all said and done, having a jury come back with a gross jury verdict of $1.25 million. Now, after the case, the other side did bring a motion, if I'm not mistaken, to have that verdict reduced by 50% to $600,000, and I'll get to that in a second. But going back to the case, before the verdict came in, a couple of other things that I did, Jim, that I didn't see a lot of lawyers doing up to that point in time, and I frankly even up through today, I don't see a lot of lawyers spending enough time getting up to speed on the facts, right? So the other thing I realized is I was emotionally and physically invested in this case. And what I mean by that was every single sentence of every single document, of every single statement, I had read, underlined, memorized, as though I was there. Okay, I spent a lot of time with the mom and dad and got to know the family well. I knew all the intimate details of, what they were doing earlier in the week before getting in the truck and driving up to the lake. I knew what their hobbies and interests were. I knew the experiences that they had as a family and how much love they had in this family and how honest they were with what they had to say, and especially with respect to what happened that morning when their son was killed. And I knew the facts. I knew the evidence. The other side probably knew the law better than me, probably at that point in my career knew procedure in federal court better than me. I know they did. That was, I think, my first or second federal court trial. And the rules are different. The rules of evidence, the rules of procedure are different. I mean, it does all come down to talking to a jury, developing rapport, developing their trust, getting them to look at you as being one of the leaders in the courtroom. If something needs to be answered, if something needs to be solved, you want them looking at you and not the other side for those answers. And so that's a consistent that I've found in all trials, especially in the big trials, that you want to strive for. You want to be upfront. You want to develop a rapport with the jury. It starts during jury selection, during voir dire, with being that person they can know, like, and trust. They know you're being straight with them. If there's a weak side to your case or an issue in your case, you're going to be the one that brings that to their attention first. They're not going to learn anything new from the other side, and you're just a straight shooter. So on this particular case, and like I said, I tried maybe a dozen cases before this in the state court, smaller cases. What I did learn was using Jerry Spence's approach to trying cases. And if you don't know Jerry Spence, check him out online. It's the Trial Lawyers College, which I've never been to, but back when I was studying Jerry's materials, I ordered the VHSs, and you put the VHS in a VHS player, and it's like a tape. and you watch. And I watched and studied Jerry Spence on voir dire, on how to pick a jury. I watched Jerry Spence on how to give an opening statement. And his approach was different back then than anyone else. What Jerry talked about was being real and speaking from the heart and telling powerful stories and relate and intertwine those stories into your jury selection and into your opening statement. You can't argue your case in your opening statement, but you kind of can. You can tell a story as to what the evidence is going to show. And so I used a lot of these approaches and a lot of these techniques in this case. I used my life experiences, those 10,000 hours, right, in this case. I focused on the relationship with my clients, people skills, showing the jury that I cared about my clients while they sat next to me, while we walked in and out of the courtroom, when we went out to lunch and came back to the courthouse and pulled into the parking lot. Everything I did showed that I cared about what was going to happen one way or the other with this family. It was everything to me. And so I was that lawyer where we were just putting our blood, sweat, and tears into this case. And when the case was done, when the jury went back to deliberate, excuse me, we weren't sure what was going to happen. The other side put on a good case. I knew that the facts that we were sharing, the evidence we were providing, the arguments we were making, I knew that it was 100% accurate based upon our discovery. And what a lot of people don't realize, but Jim, as a lawyer, you understand this, a lot of what the jury doesn't see everything. There are other witnesses, documents, things that for whatever reason, authenticity, foundation, they just don't come in front of a jury. They don't come into evidence. There are other things going on in the case that I felt might have been related to a cover-up by somebody, not defense counsel, okay, not even the insurance company, but I just think with that initial police report and the false findings and the intentional or negligent misrepresentations in that first report, something was going on. And so it kind of bothered me that we couldn't share all of this with the jury during the trial. But all said and done, the jury came back. Before the jury came back with this verdict, the other side brought a motion. And what they said in their motion, and we argued this motion for several hours in court with the jury back in the deliberation room, so it's just counsel and the judge, was they argued that under California law, our client assumed the risk of death by riding a jet ski at Lake Havasu. It was a ridiculous argument. And anytime you're participating here in California in any type of athletic activity, whether it's high school football, whether it's flying hang gliders off of Lake Elsinore, whether it's riding motocross down at the tracks, we normally sign waivers and releases, which are fine. I'm a big fan of those. I like playing in all these crazy sports, so I don't want anybody being sued for it. But you're also under California law assuming the risk. If I fly a hang glider off of the top of Elsinore and I get a wingtip flips me upside down because of a thermal activity, and it raises the wingtip and I crash and I'm seriously injured or killed, I'm assuming the risk of hang gliding. I can't sue the manufacturer. I can't sue the landowner who owns the land of the takeoff spot, and I'm okay with that, right? But in this particular case, the young man who was killed was not assuming the risk of someone else coming around a blind corner at a high rate of speed in complete disregard of the safety of anybody in front of him that would result in his death. What he did assume the risk of was either being struck by another watercraft being safely operated. What he did assume the risk of was possibly striking a floating branch several inches beneath the water, right? Hitting your foot, maybe falling off, hitting your shoulder on the branch. maybe riding under a low-hanging tree and hitting your head or your shoulder. Those are normal assumption of risk that he was assuming on that particular day. And we argued this in court. And the judge denied their motion and said assumption of risk does not apply in this particular case. So the jury came back and with a $1.25 million jury verdict. Now, in this case and in the state and federal jurisdiction, we have what's called comparative negligence. And I think what happened was back in the deliberation room, I think some of the jurors were not comfortable with awarding the family millions of dollars for the death of their son. And we're talking about funeral bills that were, $5,000 or $10,000, some medical expenses. But other than that, the damages were for the loss of love, affection, companionship in a society. We call these general damages in wrongful death cases. And I don't think they were comfortable with awarding the numbers that some of the jurors wanted to award. Now, in state court, that's not really an issue because all I need are 9 out of the 12 to find for my client. So if somebody's not comfortable with one part of the jury verdict, they can say, okay, we think the other side's at fault, and then they can go back to the dollar amount and change the dollar amount at the end of the jury verdict. In federal court on this case, if we didn't get all 8 to vote in favor of holding the defendant liable, civilly liable for money damages, then we would have lost the case. So I think there was some conversation and discussion back there. And to make a long story short, all 8 jurors came back, thank God, found in favor of our clients, but they reduced the amount of the award by 50%. So that $1.25 million jury verdict was reduced by 50%. So it was between $600,000 and $700,000. And what we ended up doing is the other side threatened to appeal. One of the things that they talked about over the phone with me regarding the appeal is that they felt the assumption of risk doctrine that we talked about earlier applied in this case, and so the jury should be 0. The jury verdict should be 0. And I pointed out to the other side that we actually spent 3 to 4 hours in court arguing the assumption of risk on the record, and that issue had already been argued, briefed, and decided by the trial judge, and they weren't aware of that. I don't know what happened, but for whatever reason, the insurance company for the other side wasn't aware that we had already dealt with that issue. So once we were able to bring them up to speed on where we were with the case, they went ahead and agreed to pay the reduced verdict, which was almost twice as much as the boat policy. If you remember, I said the boat policy was $300,000. Well, when they rejected paying that policy amount, which was part of our strategy back in the day, when they rejected that, okay, and the jury came back, even after the verdict was reduced to, whatever it was, $650,000, $675,000, they paid the difference. They paid the $300,000 policy, and then they paid the additional balance above and beyond their policy. So the insurance company had to pay almost twice as much more than twice as much than what they would have been required to pay had they settled the case back on day one when we demanded the policy. The reason that happened was there's what's called first-party bad faith. And if they had just written a check for the $300,000 and said, go after our insured, the other jet ski operator, for the balance, that other jet ski operator would probably have written a check and paid the balance, and then he would have turned around and sued his insurance company for bad faith. Why are you exposing me to this excess judgment collection effort? Why didn't you settle the case for the policy limits when the plaintiff, when Mr. Jackson and his clients made this demand a year and a half ago? And so even when a case is done like this, there are still things that can happen. There are still appeals. There's still negotiations that can take place. Don't ever assume, Jim, that the other side and all the players for the other side, I'm talking about the defense attorney, senior claims adjusters, expert witnesses, clients, round tables, which are insurance executives and senior adjusters that will round table files based on the facts and evidence that they're presented. Don't ever assume that everyone has all the information. They're super busy. Things aren't always disclosed. So as the trial lawyer, post-trial, after a verdict, make sure in today's world it's using email, text, blog post, sharing your case on your blog, all the details that your state bar and American Bar Association rules allow you to do, so that everybody's on the same page as this is where we are, this is what happened, these are our options going forward on appeal, what do you want to do? Generally, the right hand doesn't know what the left hand's doing with the other side when it comes to appeal. And you have other factors involved. You have law firms that, not in this case, but you have law firms who are billing by the hour. So if they can drag a case out on appeal, the insurance company is earning interest on the money that they're not paying out to your client. The firm that's handling the appeal is billing by the hour, whether they win or lose. What's the incentive there for them to get this thing done quickly? And so you want to make sure that you can tap into all the other procedural options that you have to maximize the chances of getting the case done sooner rather than later for your client, at the same time to generate interest on this unpaid judgment until they finally pay it. And so that's kind of where I want to wrap things up, in that once you get your judgment, especially when it's a 7 or 8-figure judgment, you want to press the right buttons under your procedural laws to start interest to be generated. So by them not paying the judgment at that point in time, if I'm not mistaken, interest, because of some paperwork that we filed, was being generated at either 8 or 10% per annum. And so the longer they took to hold off paying this judgment, the more interest our clients would be entitled to once the judgment was paid. So that kind of took me back down memory lane. I hope that made sense, and I hope the point of my life experiences that I brought into this particular case did make a difference and did allow me to sort through all the bullshit when it came to the initial reports. It helped me understand the dynamics of the watercraft operation by all sides. I should say, especially when I took the deposition of the other rider, of the adult male, and listened to his version of what happened. When he described to me how he was operating the watercraft and the throttle and any concerns regarding slowing down or braking. Remember, you can't brake on a watercraft. While I was taking his deposition, I wasn't just focusing on the facts of our case or the law. What I was also focusing on is what I knew as a jet ski operator. What he was telling me wasn't feasible at this particular location of the river in this narrow reed-lined channel. Those life experiences helped me as a trial lawyer. And my takeaway from all of this is, for those of you that are trying your clients' cases, or you're taking your cases to mediation and arbitration and then trial, especially in front of a jury, know the facts better than anyone else in the courtroom. Know your clients better than anyone else in the courtroom. Understand what the other side's arguments are and really take a step back. Don't get too close to the forest to see the trees, but take a step back and think to yourself, okay, that's their argument. What evidence do they have? What witnesses do they have? Documents? What facts? Will they be able to persuasively share that argument, that position in front of a jury, and contrast that with your case? Really, if you're not able to, get somebody else involved. Family members, other people in your firm, other lawyers in town that don't have a financial interest in the case, and really kind of lay it out for them and get their input. Stop talking and just start listening to what they think the strengths and the weaknesses of the case are. Where do they see challenges? If they were sitting on the jury, and family members are great for this, listening to the facts, what would they want to see? Here's the question you ask: what do you need to see? And I do this in opening in jury selection. Tell me what you need to see in order for me to have proven my case in your mind that the defendant recklessly operated the jet ski on the morning in question. What do I need to show you? You can structure questions like this and get a feel from the response from your potential jurors as to what you need to show. And I will tell you that you will get answers that you're not expecting. Some answers you get are not relevant. They have nothing to do with the case. But guess what? If you've got one or more potential jurors focusing on these issues and they think it's important, even if it's not, what do you think is going to happen back in the jury deliberation room when you can't talk to them anymore? And maybe one of these people has a strong personality. Maybe one of these people is going to be your jury foreperson. And if he or she's back there telling everyone else to focus on this issue that's not really an issue, maybe it doesn't have anything to do with the liability aspect of the case or the damages aspect of the case, or they're misinterpreting the facts the wrong way. How's that going to help you get a good, favorable verdict for your clients? It's not. So you need to weed this stuff out during your jury selection process. And I think by asking jurors the right way, and you need to work on this, and you have to understand who your judge is and who your opposing counsel is, because they're going to object depending on how you ask these questions. But it's like, what do you need to see for me to prove X to you? What do I need to show you in order for you to believe Y? What witnesses do I need to bring in order for you to feel comfortable? And remember that balancing of the scales we talked about. A preponderance of the evidence, a slight shifting of the scales is all I need to do in civil court, as opposed to beyond a reasonable doubt in criminal court, right? There's a different level of persuasion that's required in civil court than criminal court. And we talk about that during jury selection. I talk about that a lot. If I have two scales and on one scale I put a feather and it tips slightly, that's all I need to do in civil court to win a case for my clients. Do you understand that? In criminal courts, it's beyond a reasonable doubt. It's more than just a slight tipping of the scale. There's no reasonable doubt that what we're telling you is right or wrong. And so I'll balance all of this into this conversation. And I have a pretty good feel after I pick a jury what I need to show them and what they're expecting to see, to hear, what witnesses they're expecting me to call, right? And the more you try cases, the more you're dead on and spot on all this stuff, even before the trial starts. But for those of you trying your first couple of cases, really dive deep with jury selection and ask them, what do you need to see? What do I need to show you? The jury instructions say this, the pleadings say this, the judge is going to tell you this, opposing counsel is going to stand up and tell you this. That's great. You tell me, understanding all the above, how many people do I need to bring in to tell before you'll believe that the light was red or the light was green? 1, 5, 10, you tell me. And then depending on their answer, it allows you to either explain how the process works, confirm that that's exactly what you're going to do, or you can spend some more time back and forth, like I said, explaining the process some more and how you're not obligated to do that. And then sometimes once you explain the process to a juror, they get it and you've got somebody in your corner, not only during the trial, but back in the jury deliberation room after everyone's gone. So that was my first $1 million case. It had to do with a wrongful death jet skiing case out of Lake Havasu, and a tragic case for everyone involved. I'm glad we were able to bring a verdict home for our clients, for the family. We still stay in touch today. The husband has since passed away, but I'm still here for the rest of the family, and they know that. And they'll reach out every couple of years with a question. And after that particular case, everything else started to fall into place, right? Once you have a case like that, people will reach out with their cases. Other lawyers will ask if you'll try their cases. I mean, this is, like I said, this was back in 94, 93, 94, 95. It's now 2020. So we've tried a lot of cases since then. We've had some other pretty big cases since then. I think what I'm going to do is share other videos with you on some of the other cases that, you know, have left a memory and I think about every day. I mean, I'll remember these cases for the rest of my life. And I think good trial lawyers, they put their, you know, their heart and soul into the cases. And even when you're done, you still think about these cases, you know, at 3 in the morning. You'll still think about these cases when you see something on the news. We had a case, which I will do a video about, on a carotid chokehold. You know, police officers choking out our client's son and killing him, and took us 5 years, but we took it to trial and got a multi-million-dollar verdict for the family. And it was the right verdict. It should have never happened. And so when I see everything that's happening right now in today's world, and I've litigated this issue, I've had the experts on the stand with respect to whether or not a carotid choke, blood choke is another term, is appropriate, and how it works with police officers coming in and testifying. Just having been there and listening to everything that's being discussed, there's just so much bullshit floating around with respect to it ever being okay, because it's not, obviously. And we watched it in real time with, well, over the last couple of months with more than one person. So I think I will do a video about that. So if you guys want to see my other trial stories, subscribe to the channel. Stay in touch with me. Jump over to streaming.lawyer. And if you're a trial lawyer and you have any questions about how you want to approach a particular voir dire or an opening statement or direct cross-examination, closing argument, post-trial appeal issues, and you have questions, I mean, if you want to just chat, I'm into this stuff. You know, it's something where this is a part of my DNA, and we need more good trial lawyers in this country. I think we're the last safety net between corrupt corporations that put profits over people. And I think when you get these corporations in court, guess what? It's my client and me against the corporation sitting over there. They'll have one person sitting there and their lawyer. Okay, it's a level playing field. Other than the finances behind it, they've got the deep pockets. If you've got the facts and the law on your side, you've got a good trial lawyer that's standing up for you and dropping gloves and doing what needs to happen in court, I find that more often than not, justice is served, and you can hold wrongdoers accountable. So you guys stay connected with me over at streaming.lawyer, or go over to jacksonandwilson.com, which is our law firm website. And if you have any questions, just reach out. My name's Mitch Jackson, and remember to always make each day your masterpiece.